Hello and welcome. This is Leigh Adams from Owen, Hodge Lawyers, and welcome to the presentation, this webinar on death and discretionary trusts. Many people ask me about retirement and they say, why should I think about it? Well, of course, Australian males used to retire at 65 and die at 70. Now, if they get to 65, they've got a 50-50 chance of living another 24 years, which is almost a whole new further generation. So retirement planning is very important. They say to me, why should I think about trusts? Well, of course, lawyers and accountants have been thinking about trusts since whenever, and especially since 1985 when capital gains tax was introduced. People also ask me, why should I think about business succession and estate planning? Now, the obvious answer there is, well, if you don't think about it, you have to contend with the tax office, which have been thinking about it for many, many decades. And there are no prizes for guessing who'll come out on top when a business succession arrangement falls over or an estate planning situation hasn't been properly planned for. So turning to the issue of when the wheels fall off your estate plan, let's ask the question, does your sister control your father? Charlotte said to me not too long ago, a client, Dad said we were going to get everything equally. Charlotte was one of three sisters. Dad said to me that we were going to get everything equally between us. And there were three sisters, and all Dad had was a house. And she was driving by the house a little while ago and found a mortgagee sale sign stuck up in the front lawn. And as it had turned out, her father was an Italian immigrant. He was in his 70s. He had limited English, had had a poor education, had no business experience whatsoever. Charlotte's sister Anne had a failing business, and Anne had got her father, Charlotte's father as well, had got her father to sign a guarantee and a mortgage to support the guarantee, and spoke to her father in Italian in the presence of the bank officers, and was giving the bank officers the impression that her father understood what she was saying about the guarantee and the mortgage and Anne's precarious financial predicament. In fact, Anne had withheld key information from her father to try and maintain the appearance that everything was going well and that her father consented to the mortgage and the guarantee. The court called out Anne's behaviour and the bank's behaviour and said the conduct was unconscionable following the Amadio case. The mortgage and the guarantee were set aside, made void, and it was the bank that had to wear the loss. Of course, I asked myself, what else could Charlotte have done in those circumstances other than assisting her father in seeking an order from the court that the mortgage and guarantee be declared void? And Charlotte, of course, hindsight is a wonderful thing, but she could have asked questions of her father. She could have become or been more involved in his affairs. She should have made inquiries when she suspected something was going awry. Family culture is hard to change, and some family members are counting on you, not upsetting the status quo. So if you find some suspicious behaviour, act on those gut feelings. The fact that the answer is, oh, this is how we've always done it, may not necessarily be good enough, because the way things have always been done may not be fair or reasonable to you. What about keeping your business partner in check? Bob had operated a successful business with you since 2003. You and Bob trusted each other, you'd worked well together, the business was making a lot of money. A little while ago, Bob said, okay, how about we start up a secondary business? In conjunction with the first, we'll keep the first running, but we'll run the second one. You have second thoughts about it, you're not too sure about it, it's not quite adding up, but you get on well with Bob, you trust Bob, you've been doing business with him for many years. Okay, you say, let's open up the second business. And it turns out to be a lemon. It's a real disaster. From day one, it is losing $5,000 per week. It's now 5 years later, and Bob will not change the resolution that he entered into with you 5 years ago, whereby you agreed, and he agreed, to fund the new business, which is insolvent then and it's still insolvent, but for the funding. He will not sign a resolution changing the funding arrangement. So you are stuck. There's only 2 directors and you need his approval to change anything. He won't give it. He says things will change, and he's been saying that for too long as far as you are concerned. He takes control of the suppliers and the creditors and begins freezing you out of the business where possible. He seeks to limit your access to your own clients and taking advantage of business decisions because you're working now remotely in the COVID-19 environment and you're not as hands-on as you used to be. You want to be, but you're finding that access to information is becoming more difficult. Access to suppliers and creditors is becoming more difficult. The accounts of the new company are being merged with the accounts of the old company. There's a lack of transparency. You're very, very nervous. He won't agree to an audit. He won't agree to having a forensic review of the accounts. You're stuck between a rock and a hard place. And Bob's conduct is what the lawyers call oppressive and unfairly prejudicial towards you. And under Section 232 and 233 of the Corporations Act, you have a remedy. You can go to the court and seek an order that the sale of the shares, your shares or his shares, be affected, or that one or both companies be wound up. Probably not the solvent one, most likely the insolvent one. You can seek an order possibly that the business be sold, more likely the transfer of the shares, but there are remedies there. That's the key thing. Another example of oppression is where relief is available in such circumstances would be, for example, where you're running a cattle farm operation and you've applied for drought relief, and the benefit of this drought relief, if you get it, would be fantastic. It's taken you 7 months to get it, and you do get it, and countless hours in dealing with the government, but the government is offering interest rates at record lows. You'll be able to refinance all the debt at beneficial rates, and there'll be money left over to buy more cattle, and you get the loan, and the government says, yes, that's fine, we'll put together the loan documentation and send it to you. Unbeknownst to you, your business partner, the one and only business partner that you have, rings up the government department and says to them, we don't want the drought relief loan anymore, you can can it. And they do. And you find out after making inquiries that your business partner wanted to trigger an insolvency event for the company so that he would be able to cash in his chips and get repaid monies that the company owes him. So that triggering event and everything that he did to cause it is an act of oppression, and there's remedies available to you in those circumstances. So you can be an oppressed and unfairly prejudiced shareholder of a discretion of a company, for example, but can you be an oppressed and unfairly prejudiced shareholder, which is a trustee of a discretionary trust where you're a beneficiary? In other words, can you apply the unfairly prejudiced and oppressed concepts to a trust? You can apply them to a company. Can you apply them to a trust? Well, see, the thing here is that trustees, as we've known for many years, have to exercise their powers and discretions in good faith. We know that. Trustees cannot act arbitrarily. We know that. They can't act capriciously. They can't act wantonly or irresponsibly. Trustees can't act mischievously. They can't act irrelevantly. And they have to give real and genuine consideration to the exercise of discretion. Okay, that's good. They have to exercise their powers for a proper purpose, and they cannot act in conflict with their duty as trustee. What have I missed out? The fact is that trustees can act unfairly. Trustees can act unreasonably. Trustees can act unwisely. There's nothing stopping them doing that. These 3 things can fall, however, under the umbrella of oppressive and unfairly prejudicial conduct. So again, the question is, does that apply to trusts? And the answer is a little bit. It all started in Victoria in the Vigliarone case in 2009, where the Victorian Supreme Court said, okay, if you're a beneficiary of a trust and you happen to also be a shareholder of the trustee company, then the oppressive and unfairly prejudicial provisions of the Corporations Act apply in those circumstances. So the law is moving. There is light at the end of the tunnel in relation to discretionary trusts and other types of trusts. Now, if you want to prevent the wheels falling off, consider gaining control of your discretionary trust. How do you do that? Who are the beneficiaries of the trust? Who are the directors and shareholders of the corporate trustee? What happens if a director or a shareholder dies or becomes disabled or suffers a trauma event or develops a drug habit or becomes insolvent? What do you do then? Well, your will may need to change. Your trust deed may need to change. You may need a business succession agreement to deal with these issues. But it's a question of a stitch in time saves nine. Think about these things now, and hopefully the problem won't arise in the future. If you want to prevent the wheels falling off, then consider quorums and the use of proxies and what happens there. Take this example. There are 3 shareholders and there's a shareholders meeting and only 2 turn up, you and another. Resolutions are being passed and you're just disgusted with them, so you leave in a huff. And the remaining shareholder, who happens to have a proxy for the 3rd shareholder who is not there, that remaining shareholder with the proxy resolves to pass all sorts of further resolutions which are even more outrageous. Can he do that, or she? The answer is, have a look at section 249T of the Corporations Act, which makes it very clear that you can't have a meeting with yourself. And so the answer is no, you can't do it, which is good. The problem is many people still try to do that sort of thing, and other things that I haven't had time to mention. The better way forward, of course, is to stay at that uncomfortable meeting. Be outraged, have a voice, indicate your opposition to things that are happening in front of you in real time. Easier said than done. What about ensuring superannuation beneficiaries get their fair share? How can things go wrong there? Well, the answer is very easily. Look at the case of Katz and Grossman, leading case in the area. Father and mother are joint members and trustees. The mother dies. Father appoints his daughter as co-trustee. So the father and the daughter are co-trustees. Then the father dies. The daughter appoints her husband as co-trustee. And together they resolve that the binding death benefit nomination of the daughter's father is void. That binding death benefit nomination said that everything of the father in the super fund was to go to the daughter and her brother, being his son. The daughter and the son were to get 50-50 each. So she resolves that the binding death benefit, together with her husband, the binding death benefit nomination is invalid. And whilst we don't know from the case, we're led to assume that there's another resolution indicating that the whole lot is to go to the daughter. The son is understandably outraged, makes a claim to court, and he seeks an order that the appointment of the daughter as trustee was an invalid appointment. If the appointment of the daughter is invalid, then everything she does is also invalid and void. The problem with that is the son failed. The appointment of the daughter was valid at law. The son got nothing. So things go wrong. How do you stop that? How do you stop things going wrong in self-managed super funds, which are a form of trust? They have a trustee. They are a trust, essentially. Use a corporate trustee. See a lawyer. Have an appropriately worded enduring power of attorney. There are things that you can do to remedy these situations and stop them ever occurring. So, ladies and gentlemen, those are some of the horror stories. Think about what you want to do. Take steps in advance. Take the initiative and move forward on it before it all happens. And we'll see you next time.
Hello, my name is Dean Crossingham, Head of Accounting at Stanford Brown, and I'm very pleased to be joining Leigh Adams of Owen Hodge Lawyers for a discussion on discretionary trusts and their relationship to your own estate plan. So let's first begin by considering your own estate plan. Your wealth will likely be composed of various assets, with some of those assets housed within one or more family trusts. The starting point to considering your own estate plan in those circumstances is to clearly identify those assets of your estate and those assets of your family trusts, along with all other potential trust and estate beneficiaries, and to understand the consequences on each in respect of your passing. With this knowledge, you can then formulate a plan, an estate plan per se, that seeks to remedy any undesired outcomes so you can pass your wealth to your selected beneficiaries in the manner which you intend, and of course, to do so in the most tax-effective way. To set the foundation for a discussion on death and discretionary trusts, let's now look at the structure of a typical family trust arrangement. A trust itself is not a legal entity. It's a relationship between the trustee and the beneficiaries of the trust. It is the trustee who legally holds the assets, but it does so for the benefit of those beneficiaries in accordance with the terms of the family trust deed. Typically, and subject to the trust deed, the rights of the beneficiaries as to the capital and income of the trust are generally limited only to being the mere right to be considered by the trustee. In that sense, it is up to the trustee's decision each year on how to allocate any income and capital amongst the eligible beneficiaries. That is the discretionary nature of a family trust. An important role in a family trust structure is that of the appointor, and with no doubt, it is the most important role within a family trust. This is because it is the appointor's role to hire and fire the trustee. For that reason, it's the appointor who effectively controls your family trust's assets. What is important to recognise is that the assets and liabilities of your family trust are not directly included in your personal estate. This is because your family trust is considered to be distinct from your individual capacity. As before mentioned, your family trust is a matter between the trustee and beneficiaries. So what must you consider in your estate plan regarding your family trust, given that it's not actually included in the personal assets of your estate? I will now very broadly walk us through some common ways that a family trust is dealt with as part of an estate plan. And I'll also go through the general tax consequences thereof that must be contemplated. The threshold question that you must first ask yourself is whether you wish for your family trust to be wound up or to continue on following your passing. Under the wind-up scenario, it may be the case that the family trust just cannot be harmoniously managed by your family without your steering and oversight. Or, in order to achieve the desired division of assets, you may see that the most practical approach to dealing with your family trust is for it to be wound up. A method to achieve a wind-up outcome is to have the deed of your family trust provide that a vesting event of that family trust occurs on your passing. Importantly, note that this instruction must be done under your family trust deed and not your will. There are two potential taxing points that need to be considered under a wind-up scenario. One being relevant if you have to amend your family trust deed to include in it that wind-up instruction. And the other is relevant at the time that the family trust is actually wound up on your passing. In relation to amending your family trust deed to include the wind-up event instruction, if your family trust deed allows for an amendment of what we call its vesting date, any such amendment of the family trust deed to include the wind-up instruction will not give rise to immediate taxation. However, if you do insert such a wind-up instruction in the trust deed in the absence of a valid power of amendment in that deed, taxation will likely be imposed at the time that the family trust deed is amended. That is, before you actually do pass. A tax impost for such an amendment would presumably be undesirable, and in which case, making such an amendment to the family trust deed is generally unadvisable if the trust deed does not contain that valid power of amendment. In relation to the family trust actual wind-up upon your passing, unlike assets held in your own name, there is no exclusion for taxation from occurring in respect of those family trust assets on your passing. Again, because your family trust is separate from your individual capacity. If you do wind up your family trust upon your passing, effectively, a death tax will apply to those affected assets of your family trust. Now, the quantum of the tax, be it income tax or stamp duty or both, as well as identifying into which beneficiary's hands does the tax fall, will be a matter to be determined based on the nature of the assets of the trust and how you instructed that trust to be wound up, or otherwise how the assets of the family trust are distributed by the trustee. In summary of taking the wind-up approach of your family trust in your estate plan, there will be taxation consequences, potentially significant taxation consequences on your passing. For that reason, it is usually not the chosen approach by my clients when I assist them in developing their estate plan. Rather than winding up your family trust upon your passing and incurring undesirable taxation, you may instead choose for your family trust to continue on after you pass. So in respect of that decision, the key choice that needs to be made is who is going to control your family trust when you pass, assuming that it is you who controls your family trust at the present time. As mentioned at the start of this presentation, it is the appointor role who effectively controls your family trust, as it's the appointor who can hire and fire the trustee. So when we ask who is going to control your family trust after you pass, we are essentially asking who is going to be the appointor of your family trust going forward. Assuming you are the current appointor of your family trust, a new appointor can be facilitated by a surviving joint appointor or a successor appointor clause in your family trust deed. The appointor role can be a single person or multiple people. For example, it may be your spouse and thereafter your children who mutually act as appointors. Alternatively, a private company can also act as the appointer of your family trust, and the succession plan in respect of that appointor role is then managed via the shareholders and directors of that private company. However, if there is no explicit mechanism for the succession of the appointor role of your family trust, that role may instead pass to your executor, or it is the executor who has the power to choose the new appointor. Under any of these scenarios, your family trust will continue to exist and carry on, just as it had done before, pursuant to the terms of its deed, and of course, subject to the rule against perpetuity. The rule against perpetuity means that your family trust cannot continue forever. In New South Wales, the lifespan of a family trust is limited to a maximum of 80 years. In terms of the taxation consequences of dealing with the appointor clauses of your family trust deed, as long as the deed contains a power of amendment in respect of the appointor provisions, then there should be no taxation consequences at either the time the appointor clauses are amended and adjusted, or at the time those provisions are actually enlivened on your passing. Because of the absence of tax in that continue-on scenario for your family trust, as compared to the wind-up scenario, the decision to continue on the family trust after the controlling individual's passing, be that you, is generally the preferred path that my clients opt to take. Now that we've established that winding up a family trust in your estate plan can give rise to unwanted taxation consequences, we then need to turn our minds to consider how might you instead achieve the desired division of assets in your estate amongst your intended beneficiaries as part of your estate plan, without winding up your family trust and without causing those unwanted tax liabilities. Well, there's a few ways by which you may be able to achieve that. Firstly, as already discussed, the simplest approach is to effectively assign the family trust assets to your desired beneficiary or beneficiaries by way of change of control of the family trust through a single successor appointor or multiple successor appointors. If change of control is by way of a single successor appointor, the new appointer of your family trust will presumably appoint a new trustee who due to the discretionary nature of the family trust, will operate that trust in favour of the new appointer going forward. If change of control is by way of multiple successors or a private company acting as appointer with multiple directors, these new appointors or appointer company will then presumably appoint a new trustee which will operate under the shared control of each appointer and decisions reached effectively through agreement of the appointors. The consequence of these changes is that the assets of the family trust are effectively transferred to the desired beneficiaries of your estate by way of the control of your family trust. And that action, based on what I've already said in this presentation, should not have any immediate tax consequences for the family trust or for those new controllers of the family trust. Another way to achieve the desired division of assets from a family trust in your estate plan without triggering taxation can be by way of gifts and loans between your family trust and you, or between your family trust and other relevant people. A gift from you to your family trust will have the effect of increasing the wealth of your family trust and decreasing the wealth of your estate plan. If your gift to your family trust is not a cash gift, but it is instead a gift of property of some description, you will need to consider any potential capital gains tax consequences at the time of that gift. Whereas, if there is a loan from you to your family trust, the value of that loan will remain an asset of your estate. Your executor, via your will, can be directed on how to deal with that loan amount on your passing. For example, your executor may call on that loan balance from your trust in order to satisfy any testamentary gifts as provided under your will. If you currently do not have any loan to your family trust, and you would like to rebalance your division of assets from your family trust to your individual estate, you may be able to accomplish that via a trust revaluation reserve strategy. What that means is that provided your trust deed allows and provided you have assets within your trust with unrealized capital appreciation, you may be able to revalue those family trust assets to their market value, and that unrealized appreciation of value can be notionally distributed to you, thereby creating a debtor and creditor relationship, i.e. a loan, between you and your trust in respect to that distributed amount. Then, that amount owing can later be satisfied by the trust with a distribution of cash to you or to your executor in order to satisfy any testamentary gifts as provided under your will. With that particular strategy, it is important to consider any later tax consequences. In taxation, there is a concept referred to as specific entitlement, which is relevant when the assets subject to the revaluation strategy are disposed of by the family trust. So in conclusion of this presentation, the main takeaway points that are important for you to consider in relation to death and discretionary trusts are: The assets of your family trust are precluded from your individual estate. To deal with your family trust as part of your estate plan, it will usually require the deed of the family trust and your individual will to both include the appropriate instructions in order for you to achieve the desired division of assets on your passing. There is a decision to be made as to whether to wind up your family trust or for it to continue on after your passing. The former likely having disadvantageous tax implications as compared to the latter. And lastly, should you desire to rebalance the assets of your personal estate as compared to the assets of your family trust, you may be able to accomplish this either by way of effecting a change of control of your family trust, or either by making gifts or loans with your family trust, or a combination of all three. Thank you for listening, and I hope you have found it an informative and helpful presentation in relation to your own estate planning considerations when dealing with your family trusts. Thank you.